Hello everyone. Today in this lecture we would be talking about a few case studies. Perhaps the first thing that would come to your mind is as to what would be a case study best suitable on a certificate course which was covering issues on procedural law. Now you see, this case study perhaps cannot be something which focuses on substantive issues of law or perhaps jurisprudential aspects. The case study that I would want to share with you pertains to certain cases which were fought and the way and the manner they were fought, so as to allow you a perspective into what goes around and what essentially is required to ensure that you successfully build a career in litigation or build a career in corporate practice, as I've called it. Now you see, in this particular course, you have covered issues pertaining to Companies Act. You have also talked, discussed, and deliberated on the urgent matters of insolvency bankruptcy code. And then you've also seen as to how the issues of competition law and the practice and procedure pertaining to the same also have become really important. Now you see, the first case study that I would want to present before you happens to be a case study on competition law. Now you see, this case study is on this case of Neeraj Malhotra versus Deutsche Bank. Now you see, Neeraj Malhotra was an advocate and is still an advocate, a renowned advocate with a very strong backing in the practice of companies law as well as other civil matters and civil laws. But you see, when this competition law was being launched initially in the year 2009 and 10, and when the enforcement regime began in the year 2010, nobody was aware as to what this law is all about, how to go about it, or perhaps what would the members, as we call them, we don't have judges in the tribunal, so what would be the members of these tribunals or the commission, members of the commission, they would expect from any person who is going to litigate or practice in competition law. So you see, these were certain doubts, and then we had this landmark case of Brahmadat versus Union of India, wherein the constitutional validity of Competition Commission of India, the quasi-judicial nature, all of them were being questioned. Similar thing happened with respect to NCLT, where in the Madras Bar Association, the landmark three landmark judgments of Madras Bar Association. So over there also, the constitutional validity of NCLT was being challenged. So you see, it was an era. It was the period of 2008 to 2013 that I'm referring to, and these are very recent periods, recent years that I'm talking of. I'm not talking about some 1990s, or I'm not talking about 2000, early 2000s. I'm talking about the earliest of this decade. So you see, Neeraj Malhotra, the way he went about it was pretty simple. He filed simply a case. He made an application on a single piece of paper, and his application was pertaining to the pre-penalty payment that the banking companies charge on an individual who returns the loan amount before the stipulated time period. So you see, if tomorrow if I was to go and raise a loan from a banking company, and if at all, because of some reason, I happen to acquire certain wealth or some other source of revenue, and now if I make up my mind and I think that fine enough, the first thing that I will do with this money is that I will close my loan account. And if I was to go to the bank and I would say that, yes, you see, I had taken a particular loan from you, extended to a period of 20 years, 30 years, distributed to this tenure period. But you see, now I have sufficient money with me for some reason and from some source. And therefore, you see, I would like to close this loan account and I would want to relieve myself from this kind of a liability towards you. So now you see, in that event, the bank would have all its money back, and therefore you see, it should be a happy person. But the bank would not be a happy person. Why? Because you see, more than the principal, the early arrival of the customer simply takes away the benefit of interest. So you see, the fact or the reason as to why a bank lent you money in the first place was that you were promising them interest rates, huge interest rates, जिसमें कई बार कहावत भी ये होती है, you must have also come across this particular proverb कि मूल से ज्यादा जो आपको मूल से ज्यादा ब्याज की कीमत होती है. So more than the principal, it is the interest which simply keeps all of the business running. And if I was to tell you in English, then let me tell you the English proverb for it, and which also happens to be one of the cardinal principles of entire financial economics, which is time is the value of money. So you see, if you keep a particular amount of money invested in a particular investment option for a certain number of years, it is only then that you will be able to make money out of money. On the same principle, you have mutual funds working. No, you invest what is known as SIPs over a frequent intervals for a certain number of years, and after those certain number of years, you are returned not only the principal amount that you have accumulated, but a huge interest rate over it. So that is the entire idea, and hence you see, time is the value of money, and you see it is only the time which allows the banking company to generate more revenue from its principal. But you see, but this entire cardinal principle that time is value of money would be shattered as soon as a person who has taken a loan would simply approach or would simply come back to a bank saying that I would want to return all of the money that I have taken from you. So on that very moment, you see, the bank would lose out all the future EMIs, all the extra interest that it could have generated had you not come to the bank on a prior date. So therefore, in order to make up for that lost money and also to issue a deterrence to other people, what the bank usually does is that it levies, it simply charges what is known as a prepayment penalty. As the name itself suggests, prepayment means that a payment has been made prior to the date of maturity of loan. So you see, in that case, what the bank does is that it levies a prepayment penalty. Now that penalty is somewhere computed around 2% of the entire loan amount. So now you see, this entire case was pertaining to that prepayment of penalty. So Neeraj Malhotra, who was an advocate, his case was that you see, the fact that I have returned the money to the bank and the fact that my account did not get classified as an NPA. Third, that the fact that the bank has money in its hands and therefore it can simply give out loan to new people also. So therefore, why is the bank levying this sort of a penalty, prepayment penalty on me? So he said that this is nothing but abuse of dominant position, plus this is an anti-competitive agreement as well. So you see, that was the first case in the year 2019, and it is also the citation is also one of 2019. And you see, in that case, that's a lengthy judgment, but that's a beautifully worded judgment in which the commission went at length discussing as to how prepayment of penalty is a established international practice, and you see the banks do charge it, and they held it to be valid because that is how the business of a banking company is ensured. Otherwise, if people would take huge amount of money and they would come, or they were to come back to the bank on a shorter duration and return the entire money back, the bank would not have sufficient interest rate and therefore would not be able to run the business. So you see, that is perhaps the first case. And why are we studying this particular case study? And the reason as to why I introduced to you this case study was that you see that this was merely a commission which had not decided any case. It was not even in the infancy stage, it was just born. So therefore, you see, the first step that a practitioner must always take towards future is that he should be absolute certain about his case. If you were to read the judgment of case, you would come to know that the arguments which were advanced by Mr. Neeraj Malhotra in that case, they were absolutely fantastic. And the way commission responded to those arguments was even better. So you see, the first lesson for any practitioner is that you need not be afraid of the fact that I am not an advocate, that commissions and tribunals are only meant for lawyers. No, that's not the case. Second type of fear that generally any person has is that I do not come from a fifth generation family of lawyers, that my forefathers were not lawyers, that nobody in my family practiced, and therefore you see, why should I take this kind of risk? Now I would say, I would suggest that you see Neeraj Malhotra, when he appeared before commission, nobody else had, and this guy now would simply go into the annals of history, and he would always be remembered for the first case that he fought and the way he fought before the commission, even though he lost the case. But he set the trend. No, he laid down the foundation as to how the future cases before the commission would be handled. Now mind you, second thing, the other thing that generally people are afraid of are the procedures. What would I be required to do? Where would I get a where would I get a form, and how do I draft an affidavit? These are not your requirements. If you were to approach the commission, if you were to go before an NCLT bench, you would find there are ample number of people sitting there who would help you out on this. All that is required of you is a little bit of courage, and all that is required of you is a thorough background in knowledge, study, that you must work on your case. Now you see, there are a lot many cases that are being filed before commission, and these are being filed not by some seasoned lawyers or lawyers with 10, 20, 30, 40 years of litigation experience. These are being filed by young people, 35 years of age, 32 years of age, because you see, the very basic idea in the establishment of these commissions and tribunal was to simply do away with complex procedural requirements. The idea is very simple, and therefore you see that also is something which has been specifically addressed in all the previous lectures and the materials that have been sent to you. So you see, the basic idea behind sending those materials, behind making and making those lengthy PPTs that have been given to you and that you must have read now, the entire idea is that whenever you muster that courage, that fine enough, I would want to test the waters, and I would want to see for myself as to whether or not I can argue before these people, then tomorrow perhaps these PPTs or these reading materials would come very handy to you, in order to so as to know what procedures or what steps you must definitely follow. So that is why you see, there has been an attempt in all those PPTs to summarize the position as it exists. So you see, not the fact that, so notwithstanding the fact that you will have to undertake a lot of study on the substantive part, but you see, in fact, this particular course and the materials that have been sent to you, they would always come handy to you. They will always be handy whenever you decide to go and fight cases or litigate or practice in the matters of either Insolvency Bankruptcy Code, Companies Act, or even Competition Act. So you see, that was the first case that I wanted to discuss with you. The second case also, interestingly, pertains to Competition Commission of India also. Why? Because you see, I am giving you this case from Competition Commission of India also because this case was in fact registered by a person who was now till date never seen by anybody. This is Surinder Singh Barmi versus BCCI, Board of Cricket Control of India. Now you know that what BCCI does. BCCI is the regulatory body. It's not a governmental organization. It is a society, in fact, and a society which regulates, conducts, organizes everything and anything that has got to do with cricket. So you see, this Surinder Singh Barmi was basically a farmer, and he simply sent a letter to the Competition Commission of India. And the Competition Commission of India simply took cognizance of his letter, and they started a suo motu initiative. And that is how you see Surinder Singh Barmi has become immortal in the history of Competition Commission of India. The order that the commission passed and levied a heavy penalty on BCCI, against BCCI under this particular case, you see, that has become an immortal case. So therefore, you see, I would urge you that you please read these new economic laws as they are. Perhaps go through the reading materials that have been sent to you when it comes to procedure. Be absolute confident, and that confidence would only come once you have worked on your background once you have worked on the case laws in the best possible manner. So you see, this Surinder Singh Barmi case is also very important. Now, the next case perhaps that I would want to discuss with you, the next matter that I would want to discuss is also the one of the recent laws, but laws which have created the biggest of ripples. So you see, just like Competition Commission of India was launched in the year 2009, became and started the enforcement mechanism started in the year 2010. You see, another law which is of very recent origin is Insolvency and Bankruptcy Code. Now you see, the entire purpose of this law was that there are many companies which were established with the idea that they would make profits. However, for some reason or the other, these companies were not able to make profit. Now you see, the first thing that comes to the mind of a person who has started a company is that very rarely would he want to simply throw in his towel. Very rarely would he simply say that fine enough, if the company is not working well, I am not in a position to turn its future around, and therefore you see I would want to simply close the company. In fact, on the contrary, what most of the people, as we call them promoters, what most of the promoters of such companies would do is that they would go and they would take fresh loans, because these fresh loans would only ensure that the company simply has a chance of reviving. But let me tell you that on most of occasions, this is nothing but a ventilator service and something you are only trying to delay what is inevitable. Now, although there are other occasions as well where the companies have made a U-turn, but you see the number of such U-turns is very rare in the corporate history of India. So now you see what happens is that these people would take loans, and these loans would simply reset the clock, but it would not stop the clock from coming to an end. So you see, there were these people who would keep on taking loans from financial institutions, NBFCs, banking companies, even though they were not making profit, and only to simply allow the investors to have an idea that the company has a lot of business. So they would not only cook their balance sheet accounts, but in fact they would keep on taking loans from different sources. So you see, in the end, what would happen is that ultimately when the company would go bankrupt, or ultimately when the company would not be able to return money to its creditors, so you see, the not only the company would be devastated, the shareholders would be bankrupt or they would be ruined, but you see, the worst affected people would be your creditors. Now, why do I say worst affected people would be creditors? Creditors are those people who have given money on loan to a company for its business purposes. Now, shareholders are people who have also given money to the company for its business purposes. But the essential difference between the two is that while shareholders get to vote on the functioning and the management of a company, they have a voting right. They are allowed to sit in the boardroom meetings whenever the company makes profit and there is a distribution of dividend. They also get to earn uh, interest amount on that of thing. So you see, they are people who would drive the company. They have at least something tangible in their hand. But think of a person who has only given you loan. He is not there, who would not come to your company board meetings. He does not have a voting right. He does not have any say as to how you run, govern, or manage your company. Now when a company goes, then the shareholders do share some sort of a responsibility, direct or indirect, for this kind of a fate of a company. But then the most the most prejudiced or adversely impacted people are creditors, because they would say that we had no role to play, but we have only lost our money. Now you see, in the year 2016, the government had made up its mind and they wanted to come out with a drastic law which was known as Insolvency and Bankruptcy Code. Now what this law legislation simply did was one thing, that if any person owed a particular amount over and above rupees 1 lakh to any other person. So let's say a company which had taken loan from me of, let's say, even 1.5 lakh of rupees or anything. So any amount over and above 1 lakh of rupees. So the threshold was kept very, very low. So now if the company does not repay the money, if I have made an application for the repayment of my loan, and if the company simply doesn't repay the money, then perhaps you see I can initiate an insolvency proceeding, or CIRP, SERP as we call it, SERP, Corporate Insolvency Resolution Profession. So that process can be initiated against such a defaulting company. And mind you, within 180 days, if the company doesn't repay the money back, the entire promoters, that is the people who had established, formed, or incorporated the company, its governing mind, the family which had initiated the business, they would be thrown out, and the creditors, a committee from the creditors, would take over the management of the company. This is how drastic the rules of this particular legislation are. And therefore you see there is a huge rise, a phenomenal increase in the number of cases under IBC. And this is a law, let me tell you, which now has generated a lot of interest amongst not only the youth studying a law, but also people who are going to practice, and those who want to make a career in chartered accountancy or company secretaryship. So you see, this particular law or legislation has become a huge source not only of revenue, but of respect, and as well as an opportunity for building a splendid career in insolvency and bankruptcy code. So you see, the initial 12 cases, which are known as dirty dozen, the initial 12 cases were against the biggest of enterprises, Unsels and all these big builders. So you see, and then who were fighting those cases? These cases were not fought by only some lawyers who had 30, 40, 50 years of standing. They were fought by people who were in the age bracket of 30 to 40. If you were find, and if you were to still approach or go before any NCLT bench, you would find that because the law is very new, because its jurisprudence is very new, because there are no precedents that it would follow. So you would not find very aged lawyers or very aged practitioners going for this kind of a practice. So therefore you see, the idea with which Into the Legal World has initiated this particular certificate course, you see, this goes a long way. Now, the idea is to empower the youth. The idea is to allow them an opportunity to carve a future for themselves in these particular new legislations of corporate law. There are many other corporate legislations, be it your Stamp Act, be it your other acts, partnerships, LLPs, but you see there is a reason as to why this particular institute has carved out a certificate course only on the procedural aspects concerning these three legislations. So you see, because the jurisprudence is very new, so a lawyer or a young aspirant mind who is either studying law, accountancy, or anything, or who is genuinely interested in corporate affairs, that person is not required to undergo or to simply read, study, or mug up the old ways of civil procedure code, or is to be bound by the Evidence Act or something of that kind. So you see, this is altogether a new ball game. This is a new field with new rules of the game, and the best part is that it is merely 3 to 4 years old. So therefore you see, the opportunities under insolvency bankruptcy code are immense, and therefore you see, the PPT and the reading materials that were sent to you, they are exhaustive in nature, and that will simply give you an idea as to what importance does this code have in today's world. So you see, that is something which is very important that you must take care of. And the last thing is your Companies Act 2013. Now, the case that I would want to refer to you is a case which was fought by a battery of 8 young people. No, 8 young people who had just graduated, and they appeared before NCLT bench. The case that I'm talking about is Mehul Sandvik. Now, this Mehul Sandvik case was a very interesting case which involved examiners. So you see, there was a particular company which was found by a certain number of people, and they had simply taken services of a few people who acted as examiners for public examinations. Now they were not paid as they were promised, and then eventually these people were also the certain shareholders in the company, and therefore they lodged cases of oppression and mismanagement. Now you see, what has happened over here is that the people who fought these cases, they were not lawyers. So these people were chartered accountants. And you see, this young group of 7 to 8 people, they fought this case. Although this case was dismissed in its in the was like there was a summary order in the first hearing itself, but then you see the most important part was that these people could actually go fight cases before NCLT. Now let me tell you again that the Companies Act 2013 has oversimplified a lot many procedures. And therefore, again, you see, one of the most important and drastic provisions of the Companies Act is Section 430, which says that none of the company matter disputes can be taken up by any other civil court apart from NCLT. So you see, the opportunities for anyone to build up a career in Companies Act also, which is a very new law, which is only 7 years old, is immense. And what I find over here is, in my experience of teaching, that there are a lot many people, and the number is only increasing, of people who would want to make a career out of these legislations. So you see, if I was to summarize as to what can be learned through these three legislations, then perhaps I would say the first thing, the first most important lesson for anyone would be that you must be thorough with your substantive law, the case that you can to fight on. You must be thorough with your homework with respect to the facts of the case in hand. And thirdly, and most importantly, you see, you must be thorough with the procedural part. The procedural part is something which can also affect substantive rights and even the final outcome of a case in the longer run. So you see, it is absolutely imperative that once you make up your mind that you would want to test waters, once you make up your mind that you would want to pursue a career in practice in these particular areas, I would say that that an approach should rather start from procedural laws. You must understand first that what is required and how it is to be done. So you see, on this note, I would like to bring an end to this lecture. Thank you for your time, and thank you so much.